Well, good morning. My name is Matt Parker, and welcome to the Marshall Parker and Weber Elder Law Update for 2021. For the next 45 or 50 minutes, I'm going to review some of the top elder law and estate planning topics of the past year. And I'm also going to attempt to look ahead to some of the changes that may be coming our way in this area. Now, to keep you focused, I'm going to entertain you with some insight into one of my favorite musicians who passed away in 2020. For those of you who are music fans, particularly hard rock fans, you will recognize the distinctive colors of his guitar in this title slide. And yes, this is the guitar of one Eddie Van Halen, who was a huge part of my youth back in the 1980s. The music of his band, Van Halen, was a constant part of not only the late 1970s, but the early 1980s and beyond, since their debut hit the scene in 1978. In fact, I have a cassette tape. That dates me a bit, but I have a cassette tape of that very first album I bought back in 1983. When I heard the songs on the radio, songs like Eruption, Running with the Devil, and the cover of the Kinks' You Really Got Me, I was instantly hooked with his guitar sound. So I quickly bought each and every one of their records on cassette and promptly put a poster of Eddie Van Halen on my bedroom wall. Now, the story of Eddie Van Halen and his brother is part of rock music lore. He and his brother Alex immigrated from the Netherlands. Their father, Jan, was a musician. He had played jazz music with some of the big bands of the era. But times were tough in the Netherlands, so the family came to California in 1962. And like so many immigrants, they were extremely poor. They were in a house with two other families, and their parents took odd jobs that they could get, from dishwasher to janitorial work. But the family did encourage their sons to learn music, and they had Eddie Van Halen take classical piano lessons. He never apparently learned to read music. He would just learn to play the piano by listening to others teach him how to play those songs. Now, Eddie Van Halen's parents initially bought him a drum set, and they bought his brother Alex the guitar. But one day he heard his brother playing the famous surf song Wipeout on the drums, and he decided, well, maybe he should switch the instrument and pick up the guitar instead. And from that point forward, he rarely put it down. He was always practicing on the guitar. And he and his brother quickly became some very skilled musicians, and they joined other high school friends to form various bands, mostly playing cover tunes in high school. Now, eventually they ran into a very flamboyant vocalist named David Lee Roth, who encouraged the brothers to play more accessible music combined with a lot of showmanship. And it was Roth who decided to name the band Van Halen. They were joined eventually by bassist Michael Anthony, and they began their ascent to become one of the biggest backyard party bands in Southern California. Well, on to more serious matters. It's been over a year since the pandemic started. And for those of you in the long-term care industry, you've seen a very dramatic impact on your business. We're seeing some trends emerge in the industry that's affecting both the nursing homes and the home health care business. Now, when I spoke to you last year, I outlined the fact that there were some new billing models coming down the line for both the nursing homes and the home health care industry. For example, the patient-driven groupings model was supposed to have a negative impact on the home healthcare industry. There were some predictions that profitability of some of the smaller home healthcare businesses would be adversely affected by this new billing system, causing many of them to merge with the larger providers. Well, that was all before the pandemic hit. Although there's been an overall decline in revenue for the home healthcare industry, there has been some help in the form of government assistance. Of course, there was the CMS Advanced and Accelerated Payment Programs, along with a 2% cut in Medicare payments. Of course, these are temporary measures. They're likely going to stop by the end of 2021, when the state of emergency is expected to expire. But the consequence of the financial assistance is that there's not been a dramatic change in the home healthcare industry that the experts predicted. However, one of the looming impacts on long-term care services, both in the home health industry and nursing homes, will come from a larger player in the healthcare system, and that is the hospitals. I've seen some numbers indicating that hospitals have lost billions of dollars in revenue due to the suspension of elective surgeries and procedures. In our area here in central Pennsylvania, we have some very large providers of healthcare services that own many hospitals. How are these large providers going to deal with these financial losses that the experts estimate they are currently experiencing? Some are speculating that they may decide to sell some of their divisions in order to make the hospitals more profitable. That could include the home healthcare side of the business, perhaps nursing homes. Now, of course, these long-term care services are facing a whole host of issues brought about by the pandemic, but there's also a big player in all of this, and that's the Medicare program. As you know, Medicare Part A provides a lot of the financing for short-term stays in a nursing home, as well as the home healthcare business. Now, the fund for Medicare Part A has taken a huge financial hit during the pandemic. COVID-19 has accelerated the drain on what is called the trust fund that finances Medicare Part A. A large amount of those unemployed and not paying into the fund, along with a very large increase in Medicare payments to hospitals for COVID-related care, has strained this fund. So it's estimated that the fund is now going to run out of funding by 2024. Now, the drain on this fund is not a new issue. It's been estimated the fund was going to run out of finances by 2026, even before the pandemic hit. So there has been a longstanding issue of funding the Medicare Part A program. Now, some have suggested that home health care could be shifted to Medicare Part B to deal with the strain on Part A. Billions of dollars in spending would be shifted to Part B and other supplemental private insurance plans, along with out-of-pocket costs for consumers. Well, if that occurs, it dramatically changes the business model for short-term nursing home stays and the home health care industry. Well, in addition, the interplay between the nursing homes and the home health care industry during the pandemic is also a rather interesting trend to watch going forward. Now, the shift from serving patients in nursing homes to in-home care has been going on for some time. If you go back for the last 2 decades, you can see that there's been a sizable increase in patients receiving care in the home versus in a nursing home setting. Now, that trend is expected to accelerate after COVID-19. The large number of deaths, unfortunately, in the nursing home industry has resulted in some negative publicity. And many would-be residents of nursing homes are perhaps trying to avoid entering the nursing home out of fear of infection. Now, in addition, people are concerned about having access to their loved ones if another pandemic occurs. Thus, there's this general prediction that that there may be an increase in skilled nursing home diversions to home health care in the future. Now, the increased use of telehealth and remote patient monitoring are also big factors that will affect where people are going to get their health care in the future. Telehealth has simply exploded into a service that people are using constantly for appointments and visits. Now, if you're dealing with telehealth, you probably realize that there needs to be some focus by CMS on how home health care providers are going to get reimbursed for virtual visits beyond the emergency status that we're in right now. However, I think telehealth could be a new line of permanent business for home health care providers in the future. So experts predict that the home health care industry may still shrink in terms of the number of agencies due to the new billing practices, but the demand may increase. Many home health care businesses have seen an increase in demand, and they've in fact ramped up their hiring. So it's quite possible the long-term care outlook for home health care appears to be bright for those businesses who can stay in the industry. Now, the Coronavirus Response Act was signed last year, and it prevents states from terminating any Medicaid recipients who were enrolled after March 18th of 2020. And that's even if there was a change in circumstances which would ordinarily result in their termination for benefits. Now, all Medicaid recipients' coverage must continue through the end of the month in which the public health emergency declared by the Secretary of Health and Human Services comes to an end. That's quite frankly expected to be at the end of this year. Now, this has resulted in some unique circumstances for Medicaid recipients. Many clients that I've seen have received windfalls of available resources that ordinarily would have resulted in their termination of benefits. For example, a client who receives proceeds from the sale of a home and is now over-resourced. Or perhaps they've had a spouse that passed away and they've received an inheritance. They should no longer be receiving benefits, but instead their benefits are not being terminated even after the county assistance office has been notified. Elder law attorneys are somewhat divided on how to advise their clients on this issue. Should we voluntarily request to have their Medicaid benefits terminated, knowing that they're technically not eligible? Or should they continue to receive the benefits during the emergency in light of this maintenance of effort rule? One of the uncertain questions is how the Pennsylvania Office of Inspector General will handle a case where it was evident that the benefits were paid to a recipient who was well over-resourced and very much not eligible for Medicaid. Now, the OIG is tasked with pursuing cases of fraud, and those where Medicaid benefits should not have been paid to an individual. These cases are often referred to as overpayment cases. So the question I have is, will the OIG eventually be told to waive any claim of overpayment due to this emergency? One agent from the OIG advised me that his office has been told that they're going to have to investigate all these files after the pandemic has expired, just as they would have prior to the maintenance of effort rules. So it appears that after this emergency is lifted, Pennsylvania is going to have to decide if they intend to allow OIG to pursue a collection of these overpayment cases, or whether they're going to waive any overpayment claims if, in fact, the recipient of Medicaid benefits spends down those resources and goes back on the program within the resource rules. Now, there's been some limited exceptions to the maintenance of effort rule. CMS has stated that states can now, in fact, drop those who are not validly enrolled in the Medicaid program. So our Department of Human Services will now stop coverage when there is fraud or an agency error, as well as those cases where people have moved out of the state. In addition, DHS can shift applicants out of the Medicaid program if they qualify for what's called the Medicare Buy-In program. So the emergency, as I mentioned, is likely to continue throughout the year, but when it ends, the states are going to have to review all these cases and determine who is no longer eligible. There's going to be renewals and redeterminations. Look for a massive amount of notices to go out to all Medicaid enrollees seeking updated financial information. There's likely going to be a 90-day failure to respond period before benefits are terminated for not complying with the request for information. There's going to be a lot of fair hearings available during this process. Needless to say, it's going to be a rather chaotic time in early 22, and it may take over a year for the states to catch up with all those who are not eligible for benefits. Now, a big topic of discussion surrounding nursing homes is the issue of liability protection from civil suits related to the pandemic. It goes without saying that the pandemic has brought about a very unique set of circumstances that were so very unprecedented for nursing homes. Many facilities could not simply control the spread of the virus, particularly in the early stages of the pandemic. A large percentage of those who have died from COVID-19 were in fact in nursing homes, an estimated 174,000 lives across the country. Now, the federal government has not stepped in to provide liability protection for nursing homes. So the lobbying effort is focused on the state level. To date, 27 states have enacted some form of liability protection for nursing homes related to the pandemic. Most of these state statutes provide liability protection from civil claims, provided the conduct of the facility was not grossly negligent or reckless. Now, Pennsylvania is not one of those states. Governor Wolf vetoed House Bill 1737, which would have temporarily extended civil liability to not only nursing homes, but hospitals, labs, businesses that distribute PPE equipment, and EMS providers. There would have been civil liability immunity from claims that there was exposure to COVID-19 during any treatment or testing in one of those environments. Now, the bill, in fact, protected a provider or business so long as there was a good faith effort made to comply with the public health guidelines, including state and federal orders. It also protected providers from vicarious liability claims for the conduct of their own employees. Unfortunately, the bill included some liability protection for other interested parties that were not related at all to the COVID-19 protections. For example, there was some liability protection for farm tours and farm entertainment. So while there were a lot of groups supporting the bill, Governor Wolf was somewhat dismayed by the rather broad language in the bill that he felt would have protected those who didn't comply with reasonable steps to protect patients and residents. However, by executive order, the governor did provide protection for licensed or certified healthcare practitioners providing patient care during COVID-19. So there is protection for individuals from malpractice claims. Now, given the broad support from the public for some form of liability protection for this area of our public, it is likely that another attempt will be made with a more narrowly tailored scope in the future. Now, throughout the pandemic, nursing home visitation has been a source of frustration for residents and their families. Following the Center for Medicare and Medicaid Services guidelines from a year ago, nursing facilities restrict visitors and non-essential healthcare workers except under certain compassionate care situations, such as end-of-life cases. Now, CMS guidelines have evolved over the past year. In September of 2020, they encouraged indoor visitation as long as there was not an outbreak. Now, with the administration of all of the vaccines, the infection rates have dropped significantly. So in March of 2021, CMS further encouraged states to loosen restrictions on visitation. The revised guidance has 3 types of visitation scenarios. First, the facilities should allow responsible visitation at all times for all residents, regardless of vaccination status of the resident or the visitor. They can limit visitation for unvaccinated residents if the COVID county positivity rate is greater than 10% and less than 70% of the residents in the facility are fully vaccinated. In addition, those residents with confirmed COVID-19 infections and those in quarantine can have visitor restrictions until they are cleared. Now, there is additional visitation guidelines for facilities that are suffering an outbreak. Facilities can restrict visitation until they have done the required testing and determine the location of the outbreak. Then the visitation can continue to other areas of the facility not affected by the outbreak. For many facilities, I suspect an outbreak will bring an end to visitations until the testing has been determined that it's been brought under control. Now, lastly, CMS advised that for compassionate care visits, such as end-of-life scenarios, visitations should be allowed at all times for any resident, whether they're vaccinated or not. Sadly, I did see the painful effects of a no visitation policy earlier in the year when more than one of my clients struggled to get in to visit a parent or a spouse who was actively dying. Part of the problem for some facilities is how they're going to host visitors. Keep in mind, the CMS guidance places no obligations on the facility to require visitors to be vaccinated. Given the risk, I suspect many facilities will not allow visitation in resident rooms. As the weather improves, outdoor visitation is a likely solution for those wanting to comply with visitation guidelines, but not put their staff and their residents at risk. Well, once David Lee Roth joined Van Halen, they became local sensations in their hometown of Pasadena, California. They attracted a huge following, including large local concerts and some backyard parties. Kids in the wealthy section of town would contact the band about a party they wanted to put on, and they'd advertise for it while their parents were out of town. Van Halen became the band to call for entertainment, as they were sure to attract a large crowd. At one such party, the police were called, and there was a large raid, property damage, lots of arrests. It made the news with the parents seeing their home raided by the cops on TV while they vacationed down in Mexico. After paying their dues in local clubs, Van Halen made their way to Hollywood, where they became the house band at a famous local rock club called Gazzarri's. However, their breakthrough came when they played the club called the Starwood, and eventually be discovered by famed record executive Mo Austin and producer Ted Templeman. Their debut album was recorded in just weeks and became an instant smash in 1978. To date, it has sold over 10 million copies. I have 5 of those copies in my collection. Now, it was Eddie Van Halen's guitar style that wowed fans and other musicians. The speed, dexterity, and style with which he played was revolutionary for the time. He played notes with a very unique style of tapping the guitar using both his left and right hands at the same time to play notes on the fretboard. In doing so, he increased the speed at which the chords could be played, as evidenced by the instrumental song Eruption, widely regarded as one of the greatest instrumental songs of all time. He also gained a reputation as a very creative musician, building his own guitars and amplifiers to get the sound he wanted. His so-called Frankenstrat guitars, often appearing with the distinctive red, white, and black colors, were in fact built by him. After their debut, Van Halen went on to record a string of million-selling follow-ups and hugely successful tours. Hits included Dance the Night Away and The Cradle Will Rock Unchained, and a cover of Roy Orbison's Pretty Woman. Well, last year, I discussed the Secure Act, the federal legislation that had a host of provisions intended to help more people save for retirement via tax-friendly retirement accounts. For estate planning purposes, the Secure Act also includes a change that affected most non-spouse beneficiaries who inherit an IRA or other retirement plan on the death of the account owner. Now, this change affects what is commonly known as the ability to stretch retirement accounts over time. Now, under the old pre-Secure Act law, designated beneficiaries who inherited an IRA were permitted to spread out their withdrawals from the account over their own life expectancies. For younger beneficiaries, these withdrawals could be deferred for 20 or 40 or years or more. During this time, the accounts could grow on a tax-deferred basis with only yearly required minimum distributions being taxed. This was referred to as stretching the IRA. Now, under the Secure Act, most non-spouse beneficiaries will now be required to withdraw all of the money in the inherited account within 10 years of the death of the account owner. This can create a major income tax problem for beneficiaries of much larger accounts. Interestingly, there was a recent IRS publication indicating that during this 10-year period, the required minimum distribution has to be taken in any of the 10 years where there are no other distributions. That conflicts with some of our thoughts about how this law was to be applied. Many practitioners thought you could take it all out in 1 year or just delay taking it out until the 10th year. Now, estate planners and financial advisors have been trying to address the plan for their clients in light of the loss of these stretch benefits. As I mentioned, large accounts are particularly at risk. Since I spoke to you last year, here are some of the interesting planning options that people are still discussing a year later. First, the conversion of traditional IRAs to Roths is typically at the top of most financial planners' list of ways to deal with the loss of the stretch IRA. And particularly given the government's spending over the last year or two, we're almost assured of an increase in the income tax rates. So Roth IRAs require the taxes to be paid before the account is funded, and the distributions thereafter are generally tax-free. So some clients might benefit by paying the tax now on a traditional IRA and converting that account to a Roth. Second of all, spending the IRA before other assets might be advantageous from an income tax standpoint for some of our retirees. If our clients are in a lower income tax bracket during their retirement years, some financial planners might advise their clients to shift their thinking about what assets should be spent during retirement. In the past, clients might only have taken the minimum distribution from their IRA and then use that account only as needed for other expenses. They figured it was a really great vehicle to pass on to the next generation. Well, it's not so much anymore, particularly for the larger accounts. So why not use the IRA for household expenses, trips, gifts to children, gifts to charity? Most clients would rather enjoy those funds than have their children pay such a large percentage in income taxes to the government. Clients may also want to consider passing on other savings to children, pass on the mutual funds, the stocks, the real estate, and other investments rather than the IRA. They may want to think of the IRA as a primary source of spending once they reach retirement. Next, rethinking the beneficiaries of the IRA is also very much in play. Normally, the beneficiary has been the spouse who has the ability then to stretch the IRA over his or her lifetime. However, it may be beneficial to pass on some of the IRA to the next generation at the death of the first spouse to die. The idea is to distribute the taxable proceeds in steps with the hope that you'll reduce the impact of the income taxes. In conjunction with this idea, we've seen some discussion about using disclaimers as part of the estate plan. A disclaimer is a decision not to inherit an asset from a deceased person. So you can use them where you might be left money or property in somebody's estate, that is through a will, but you don't want to inherit your share for some reason. Therefore, you disclaim and allow the share to pass on to the person or persons that are named after you. So using this idea in the IRA allows you to pass on inherited funds to the contingent beneficiaries who might be in a lower tax bracket. So in the traditional family, we might leave some of the IRA to the spouse, but a share to two of the children. Then they can decide if they want to inherit their share of the IRA. If they don't, they can disclaim and leave their share to the grandchildren, either outright or maybe in trust. Thus, the breaking up of the IRA over multiple generations is a popular way to try and reduce the income tax liability of these accounts. And lastly, I'll mention that for those charitably inclined, the IRS did bring back the qualified charitable distributions, which allow those with an IRA to divert all or part of their required minimum distribution to charity. Of course, they did come back because the required minimum distributions were not required in 2020 due to the CARES Act. Now, digital assets have become a common part of our lives. Many of us have some property stored in digital form. We could have photographs online, maybe ebooks, music and movie files. Some of the content is on social media platforms, from Facebook through other services like Apple or Amazon. There's no longer a physical form for these items, but this is all digital and it's saved somewhere in the cloud. Well, until the passage of the Digital Assets Act last year, there was no guidance directing how executors, trustees, agents under a power of attorney, or even guardians could control and transfer these digital assets. When we die or become disabled, the question has always been, how will our representatives get access to these files? They are not on our computer, but they're saved in a computer server somewhere far away that can be accessed via a username and a password. Could the power of attorney or the executor of an estate go get the digital property and then transfer it to another person? After all, you paid for those music files. Why can't you transfer them to somebody else, just like you could transfer a physical musical form, such as vinyl or a cassette? Now, the new act now provides authority to access an individual's digital assets or electronic communications, and it gives a framework for those companies who have control over these digital assets to then safely disclose their content. So companies can, first of all, use what is called an online tool to direct how access will be permitted. For example, Google has created an inactivity tool that allows the user of Google to decide if someone will have access to their account. Now, if these online tools are used, the Digital Assets Act states that these tools can override any directions you may leave in a will, a power of attorney, or a trust. I sometimes think of these online tools as setting forth the beneficiary or designating who will have access to your account. It's very contractually oriented rather than relying on an estate planning document. In the absence of an online tool or a designated recipient, a user may now designate in a document like a will, a trust, or a power of attorney the authority of a fiduciary to access some or all of these digital assets. This will also include the content of any electronic communication. So this covers emails. Now, the use of this law may in fact override the term of service agreements by the company in control of the digital asset. So those term of service agreements where you sign up for an account and they say, you have to agree to these terms, and in order to use the account, you just have to check that box. That's what they're talking about. This law will override those agreements. The law states that if a user agreed to disclose the content of the electronic communication in a document like a will, trust, or power of attorney, then the company must disclose the content to the person you named in these documents, known as a fiduciary. As we get into these estate planning questions with our clients, we're going to have to ask them, hey, do you have social media posts or emails that you want to disclose at your passing? Some might rather the content at least of their emails not be disclosed. And I should point out that if you have deleted digital assets, those don't have to be disclosed to the custodian. So if you have deleted emails, those are not going to be disclosed. Now, if the user did not consent to the disclosure of the content, maybe their document is silent on this topic, the company still has to disclose a catalog of electronic communications. So For example, with emails, you would be limited to the identity of the sender of the email and the recipient, the date and the time of the communication, and the email addresses. The catalog is just not going to include the content of these various emails. So most practitioners are now going to have to update their documents, wills, trusts, powers of attorney, perhaps mention digital assets. With our younger clients that are coming down the line, we're going to have to ask them, do you have online accounts? Just like we ask them, do you have real estate or stocks? It's an asset that they do in fact have. And we have to discuss with them, hey, have you exercised your online tool with Google or Facebook? If not, do you want to disclose or pass on ownership of digital content and property, if you will, to your beneficiaries? There has to be some sort of challenging or complicated discussion about what is it you have and what is it you want disclosed, because some of this content may be sensitive and they may not want it disclosed at all at the time of their passing. All right. Well, last year, Pennsylvania had temporarily lifted the requirement that notaries had to be physically present to witness a required signature. However, in October of 2020, Act 97 was signed by Governor Wilk, making remote notarization a permanent option. Now, the initial goal of waiving the physically present requirement was to allow contracts as well as estate planning documents to be signed virtually. In fact, there was a memorandum put out to that effect. The reduction in contact when signing documents was also intended to help prevent the spread of COVID-19. Now, in order to use remote notarization, notaries had to actually acquire virtual notarization technology that allows them to both hear and see the person signing the document. All of the other notary requirements still applied, including establishing personal appearance, getting identification down, make sure there's no duress and the person's aware of what they're signing. Now, under Pennsylvania law, estate planning documents that require notarization include financial powers of attorney, self-executing wills, and temporary guardianships. Typically, we also had advanced directives and healthcare powers of attorney notarized, even though that was not required in the law. Now, estate planners soon realized that their whole remote notarization idea was better in theory than in practice. First of all, we realized the Pennsylvania Electronic Transmission Act bars the use of electronic signatures on wills, codicils, and testamentary trusts. Even though the document could be notarized, we don't have a law that allows electronic signatures for these documents. Furthermore, the Uniform Electronic Transmission Act, which was the basis for Pennsylvania's virtual notarization law, it was the national law, if you will, it applies to businesses, commercial, and government transactions. It states clearly that unilaterally generated documents such as estate planning documents would not be covered by that act. It therefore stands to reason that they're not covered by the Pennsylvania virtual notarization law. So additionally, one of the practical problems we had when looking at the law is that the law surrounding the creation of wills, trusts, and powers of attorney has not been modified. Pennsylvania still doesn't recognize electronic wills. The laws surrounding the creation of these documents anticipates what's called a wet signature, typically made by a pen or a writing instrument by the person signing the document. The whole remote notarization software allows the parties to make electronic signatures, the kind you make when you sign your name if you're using a credit card at the local store, but there's no original document that's actually been signed in ink. Making the use of this whole remote notarization even more frustrating is that we realize that we cannot use the technology to notarize the witness's signature to estate planning documents. The law only applied to the person signing the documents. We do know of an actual case outside of Philadelphia where a practitioner decided to attempt to use this virtual notarization of a will. The Register of Wills rejected the electronically notarized document as not in compliance with what's called our Probate Estates and Fiduciaries Code, which relates to formalities of a properly executed will. So it appears that the use of the virtual notarization is most helpful in business and commercial settings. It's used a lot in real estate closings. In order to make the virtual notarization helpful in estate planning businesses, we're going to need to have some legislation that overhauls the PEF code to allow for electronic signatures to be honored just as a signature made in ink would be. Well, thanks to MTV, Van Halen crossed over from revered hard rock act to a mainstream band that was played on top 40 radio. Eddie Van Halen decided to experiment with keyboards for the sixth album entitled 1984. The band's #1 song, Jump, was played constantly on the radio, and the video for the song became an MTV classic. Relatively inexpensive music video introduced the charismatic guitarist and the lead singer David Lee Roth to the masses. In addition, Eddie Van Halen also recorded what is arguably his most famous guitar solo, that on the Michael Jackson song Beat It. He was asked to do the solo by the producer of Thriller, one Quincy Jones. It took about 30 minutes to rearrange some of the song and cut one of the most thrilling 30-second guitar solos of all time. Interestingly, he did not ask to get paid for contributing his solo to the song. Beat It has sold 7 million copies and is one of the best-selling singles of all time. The 1984 album spawned 4 hits, including Panama and I'll Wait, and went on to sell 10 million plus copies. The resulting tour was a success, but relationships were strained with lead singer David Lee Roth, who started to grab more and more of the attention at the expense of the band. At the end of the tour, the band split with Roth and recruited a new frontman, Sammy Hagar. Around this time, Eddie Van Halen married Valerie Bertinelli. She was an actress, famous for her role as Barbara Cooper on the 70s and early 80s TV show One Day at a Time. They were together for over 20 years and had a son named Wolfgang. Well, there are 2 bills in Harrisburg to watch over the next year. The first is a revision to the Older Adult Protective Services Act. This is the law intended to help protect our older adults from imminent risk of financial exploitation and other forms of elder abuse. The changes are directed in part to those who work closely with the elderly. There would be changes to the background checks for all employees, both new and current, who work with adults in the long-term care setting. There is a lifetime employment ban that was initially sought in an earlier version of the law. However, that was declared unconstitutional. This version intends to remedy the constitutionality issue and provides for updated employment practices for those in the elder care field. Financial institutions, you should look out for some provisions that are intended to help you intervene if you suspect an elder is being financially abused. And the provisions related to mandatory reporters is also to be updated, including the procedure for reporting and the investigation that follows. The bill unanimously passed the Senate during the last session, so it does have bipartisan support, and most believe it's going to become law in the next year. Now, there are recommended improvements to the Family Caregiver Support Act found in Senate Bill 1368, and they are aimed at increasing the amount of funds available to caregivers under this program. The Family Caregiver Support Act is intended to help reimburse those people who are caring for another adult or a child in their home. Unfortunately, the amounts available for participants under this program haven't been changed since 1991. Currently, there's a monthly cap of $200 for a care plan and $300 for reimbursement of out-of-pocket expenses. So the Department of Aging is really pushing to raise the amounts available for these services. Now, there's also a lifetime maximum limit of $2,000 for the reimbursement of home modifications, such as ramps and chairlifts, and that is woefully out of line with the current contracted costs. With these small reimbursement figures, the money allocated to this program is just not being utilized like it should be. With more realistic figures, the program would be used more by those in need. Now, keep in mind that the program is only available for those people with lower incomes. The eligibility income levels range between 200 and 380% of the federal poverty level. I will say when the act was last revised in 2011, 10 years ago, the legislature did not increase these reimbursement figures. Now, as most of you are aware, the observation status refers to those people who are in a hospital bed, but they're not classified as an inpatient for Medicare purposes. Thus, the care is covered under Medicare Part B. Now, if the admission was classified as an inpatient, then the care would be covered under Medicare Part A, where there's a one-time deductible for the first 60 days of hospitalization. Now, with Medicare Part B, there is also a copay of 20%, and that shifts more of the cost of care to the consumer or their private insurance. Now, last year, a federal court ruled that when patients to a hospital are originally admitted as an inpatient, and then they have their status switched to observation status, they have the right to appeal that change to Medicare. In fact, patients who had their status changed from inpatient to observation status as far back as 2009 are now allowed to appeal that status. If their appeal is approved, Medicare should pay for those services that were not covered. Now, those services would include the nursing facility care, since the 3-day hospital stay could not be achieved for the purpose of covering any skilled care needed at the skilled nursing facility if they're in an observation status. Now, under Medicare Part A, you can get up to 100 days of skilled care in the nursing facility, but the 3-day stay has to be an inpatient status for that to occur. Now, I will point out that during the pandemic, the 3-day hospital stay for purposes of qualifying for skilled care in a nursing facility has been waived. It applies now to all individuals, not just those who with a COVID diagnosis. But all the other skilled nursing facility coverage requirements continue to apply. Well, here is a sad sign of the times that was just introduced last month. The Federal Emergency Management Agency began accepting applications for its program to assist families with the financial expenses of funerals for COVID-19 related deaths. FEMA's COVID-19 Funeral Assistance Program will continue to reimburse individuals and households for COVID-19 related funeral expenses incurred after January 20th of 2020 to help ease some of the financial burden caused by the pandemic. The program is funded with about $2 billion from both the CARES Act and the American Rescue Plan. FEMA says applicants who were responsible for the funeral expenses of multiple deceased individuals can apply for assistance for even more than one death. However, the assistance is limited to a maximum of $9,000 per funeral and a maximum of $35,500 per application. Now, to be eligible for funeral assistance, you have to meet several conditions. First, the death has to occur within the United States, including its territories, the District of Columbia. The death certificate must indicate the death was attributed to COVID-19, and the applicant must be a U.S. citizen who incurred funeral expenses after January 20th of last year. However, there's no requirement that the deceased person had to have been a U.S. citizen. Now, when you apply, you need an official death certificate, some funeral expense documents indicating the amount of the funeral and the dates the funeral expenses were incurred. You also need to show that proof of funds received from other sources didn't pay towards the funeral, so they don't want to pay for funeral services if there was a prepaid burial account or funeral insurance. Those who qualify can complete an application by calling FEMA's COVID-19 Funeral Assistance Line. As I discussed in the past years, Pennsylvania has now transitioned to a managed care plan for those older adults and persons with disabilities who are getting long-term care services, whether it's at home or in a skilled nursing facility. Community Health Choices changes how individuals get their Medicaid coverage. It's been transitioned from a fee-for-service plan managed by our government to a managed care plan that's managed by private insurance companies. So one of the interesting consequences of this transition is the effect on what's called the estate recovery program. Estate recovery relates to the Medicaid program, and the government is required from the estate of an individual who received Medicaid any benefits they were paid during the time they were on the program. Now, Pennsylvania is required to recover the total what's called capitated rate charged by a managed care plan for services when collecting against an estate subject to the Medicaid estate recovery program. So the capitated rate is a fixed amount of money billed to Pennsylvania by the insurance company for each month that services are provided to a patient. Now, what this has led to are cases where the capitated rate far exceeds the services that are actually received by the Medicaid recipient. What we elder law attorneys are finding is that this estate recovery statement of claim includes capitated payments in months where our clients were not even eligible for services due to perhaps gifts, maybe transfers of assets have been made. My client's not eligible, and yet the insurance companies are billing in those months where they're not eligible for services. And most of these cases, what we're finding that if we place a call to the estate recovery program, we can resolve this issue and the charge is removed. However, keep in mind, not everybody's represented by an attorney who's going to recognize this inconsistency and may not be sophisticated enough to contact the estate recovery program and ask why they were being billed when they did not receive any services. Now, in 1985, Van Halen released their first album with Sammy Hagar, entitled 5150. I, like so many Van Halen fans, bought it and wore out that cassette. It sold 1 million copies in 1 week. There were differences between the Van Hagar era, if you will, and the David Lee Roth era. Since the song Jump propelled them to the top 40, the band decided to take a more pop direction with many of their songs. There was the hooky Why Can't This Be Love, the ballad Love Walks In, and the soaring song called Dreams, all of which helped make 5150 the band's first #1 album on the Billboard charts. Unlike David Lee Roth, Sammy Hagar was a very talented singer with a tremendous range. He had a very successful solo career and a prior stint in revered 70s rock band Montrose. The equally charismatic singer was a talented songwriter as well. He and Eddie Van Halen bonded and made several more successful records. Each one of them went on to the top of the Billboard chart, producing numerous hit songs such as When It's Love, Finish What You Started, and Right Now. While the fans may not have enjoyed those Sammy Hagar years as much as those 6 albums they made with David Lee Roth, they still bought those albums by the millions in large part to hear Eddie Van Halen play guitar. Well, there's an estate planning topic that arose this year amongst the world of songwriters. While the subject of selling royalties may not be relevant to most non-musicians, it is relevant to all of you who have an asset or assets in your estate that may be difficult to disperse as part of your estate plan. So Bob Dylan stunned everybody by selling his entire catalog of songs for $300 to $400 million. It is estimated that this was the biggest acquisition ever of the music publishing rights of a single songwriter. His career spanned 6 decades and featured more than 600 songs. Now, other big-time sales followed, including Stevie Nicks of Fleetwood Mac, who sold her catalog for an estimated $100 million. Neil Young, Shakira, Smokey Robinson, even Motley Crue's Nikki Sixx sold all or part of their songwriting for huge dollars. So why the sudden desire to offload a consistent source of revenue for songwriters? Well, the boom in streaming services has caused a boom in valuation of music. The data from these streams makes it easier to value a song's worth and guess its future earnings. So songwriting catalogs are commanding 10 to 18 times annual royalties. Songwriters want to take advantage of the sale now while the value of their asset is up. While there are music-related reasons for selling now, such as the drop in touring due to the pandemic, there are also some practical estate planning reasons related to why an artist wants to sell now. First, some of the tax reasons. The capital gains tax rate could go up in the future. Right now, it's at 20%. Current administration wants to raise it significantly. So if these artists aren't going to take advantage now of the low capital gains tax rate, they might have to pay a lot more in taxes in the future. More importantly, I think artists don't want their catalogs to be fought over in court. Take a look at some of the estates of recent and deceased musicians, and you'll find family members fighting over how to control this royalty stream. The estate tax is also a large reason why artists might want to avoid owning their royalties at death. You might also take a look at Prince's estate, where the IRS decided his royalty stream was worth a lot more than the administrator valued it. They want an additional $39 million in estate taxes. So how does all this relate to us? Well, do your clients have complicated assets that are part of their estate? Perhaps they have multiple rental properties. How about a family business? Do they have collectible assets like cars or paintings? Well, you may be facing some of the issues that these songwriters are facing when you pass away, owning these rather complicated assets that are difficult to manage and dispose of. If you plan on selling during your lifetime, you may avoid the complexities and challenges that estates face when they're trying to liquidate these assets. Valuing the assets, finding buyers, disputes with beneficiaries, all the issues that administrators face when dealing with unique assets that are part of an estate. It's much, much easier to distribute cash or liquid investments. So if you don't have to be a songwriter selling a valuable catalog of songs to understand why it may make sense to liquidate some of your physical investments during your lifetime to avoid the challenges of administration after you are gone. Here is yet another story of a famous celebrity who engaged in estate planning that will likely result in a protracted court battle. Larry King was primarily known as a television interviewer, famous for his CNN show, Larry King Live. He led a very colorful life, having been married 8 times to 7 different women. He had 5 children and 9 grandchildren. His last wife was 26 years his junior. They had just filed for divorce prior to his passing. Although he had a professionally prepared will in 2015, Larry King apparently drafted a handwritten will prior to his death. Now, a handwritten will is called a holographic will. A handwritten will should meet all the requirements of any other will, including requiring the testator to have capacity. In this case, there were two witnesses to this holographic will. Now, even if this will is admitted to probate, it reportedly only controls a fraction of Larry King's wealth. A large percentage of his estate is in a revocable trust, roughly estimated to be about $50 million. Did he intend to alter the disposition of the trust in addition to the will? If so, he failed to do so with the execution of the handwritten will that would only control the disposition of his estate. Reportedly, King did not have a nuptial agreement, nor had he reached a financial settlement in his divorce. California is a community property state where a spouse is entitled to 50% of the marital property. His surviving spouse was married to him for 22 years before he died, and she is, in fact, the mother of 2 of his 5 children. She's reportedly claiming that Larry King was highly susceptible to outside influences when he signed the handwritten will in October of 2019. She is seeking to set it aside, so it doesn't look like Larry King's estate will be settled anytime soon. Well, in the later years of Eddie Van Halen's life, he had more than one reunion tour. First, there was one with Sammy Hagar in 2004. 3 years later, he and David Lee Roth reunited for a tour that grossed more than $90 million. His son Wolfgang joined the band as its bassist, and they released a well-received reunion album with David Lee Roth. By all accounts, Eddie Van Halen was a chain smoker. Personal accounts state that once he stopped smoking a cigarette, he would immediately light up another. That habit caught up with him in the early 2000s when he had to have part of his tongue removed. The cancer returned and eventually took his life in October of 2020. Eddie Van Halen's death was mourned by millions of fans who were entertained by his music and the many musicians who were inspired by him. Many called him the Mozart of guitar. I was lucky, very lucky, to come of age when Van Halen was at their peak. Their music will be with me forever. So rest in peace, Eddie Van Halen. And that brings to an end the 2021 Elder Law Update. I want to thank you all for attending, and I do hope to see you in 2022.